Hello, this is one of a series of recorded webinars regarding recent legislation. This particular webinar topic is intellectual freedom, diversity training, and the Pledge of Allegiance. The department has previously released written guidance on these four topics. That written guidance is available on the link on this slide. It is available in the Equity Education tab at the Iowa Department of Education's webpage, educateiowa.gov. There are four topics which we will discuss in this webinar: House File 744, Student Free Speech; House File 802, Racism and Sexism Training; House File 847, the component of the Education Practices Bill dealing with the Pledge of Allegiance; and House File 868, the components of the Education Appropriations Bill dealing with diversity, equity, and inclusion requirements. So the first is House File 744, Student Free Speech. This bill, which is effective July 1, 2021, applies to school districts, and it requires districts to protect students and practitioners' intellectual freedom and establish and publicize policies that protect students and faculty from discrimination based on speech. This provides for enforcement of this intellectual freedom policy, including employee termination and referral to the Iowa Board of Educational Examiners. The bill also creates a ground for license sanctions from the Board of Educational Examiners. That is the indented bullet, and I would defer any questions regarding that ground for discipline by the Board of Educational Examiners to the board itself. So a little bit of context to the language on intellectual freedom. This bill establishes and confirms a right to intellectual freedom, but that right is not complete freedom. This schools remain an academic environment. School classrooms and hallways are not a traditional public forum as a sidewalk or a park might be. And schools operate under compulsory attendance law. So the speaker and the listener are required to be there in a way that other contexts for free speech speakers are not, and listeners are not required to be present. So the guidance document calls out several Supreme Court cases. The purpose for intellectual freedom is to prevent school districts from casting, in the words of Justice Brennan, a pall of orthodoxy over instruction. But intellectual freedom is not unlimited. It is not a sort of like a magic wand that you could wave over speech and instantly it becomes protected. Speech that materially and substantially disrupts the school environment is not protected under the Supreme Court's Tinker case. Speech that is a crime, such as false report or disorderly conduct, is not protected. Speech that is bullying and harassment is not protected. Speech that is academically dishonest, such as plagiarism or cheating or infringement upon intellectual property, is not protected. Speech that is not responsive to an assignment. The example in the guidance document, a student is asked to describe the current scientific consensus regarding climate change. If the student in a well-written answer says that climate change is a hoax, that is not responsive to the question and it deserves a low mark. Contrast that with an assignment where a student is asked to describe her or his personal views on global warming and climate change. If the student in a well-constructed essay says that it is a hoax and warming is attributable to natural non-human causes such as solar cycles, and the student receives a low mark, that calls into question whether or not the student's intellectual freedom has been honored because the student responded to the question. A low mark would suggest that further interrogate whether or not the student's intellectual freedom has been violated. And then the one final example is taunting or unsportsmanlike conduct by participants or spectators in interscholastic athletics. The next couple of items regarding House File 744 makes changes to the statute governing schools' publication codes, the statute that governs school policies regarding student magazines, yearbooks, and newspapers, requires that the written expressions code contain and set forth the content of section 280.22 as amended. And it provides protections to public school employees or officials from termination, non-renewal, or other retaliatory action for acting to protect the intellectual freedom of students or co-workers, or refusing to infringe on student conduct that is protected by this section. Moving on to House File 802, which is the parameters or guardrails around racism and sexism training. Each school district superintendent must ensure that mandatory curriculum and mandatory training provided to staff or students does not, quote, teach, advocate, encourage, promote, or act upon specific stereotypes or scapegoating towards others based on a group membership or identity. What this assurance does not do is it does not prohibit the person providing that curriculum or training from answering questions. It does not limit discussions of diversity, equity, and inclusion outside of mandatory curriculum or mandatory training that are part of a broader academic discussion. House File 802 requires that a school district's diversity and inclusion efforts discourage students from discriminating against other students based on political ideology or any characteristic protected under federal civil rights law or state law, and further requires a district to prohibit its employees from discriminating against students or their coworkers based on political ideology or any other characteristic protected under federal or state law. Short answer to a commonly asked question: may schools continue to offer diversity, equity, and inclusion training to their employees? Yes, subject to the term of 802. School districts still are permitted to continue training that fosters a workplace and a learning environment that is respectful of all employees and students, subject to the guardrails that House File 802 stands up. A couple other items in House File 802 and the guidance that the department issued. What are the characteristics protected under the Federal Civil Rights Act of 1964? Color, race, religion, sex, and national origin. Based on a U.S. Supreme Court decision, applied the ban on sex discrimination to include discrimination based on sexual orientation or gender identity. As a matter of caution, consider the Americans with Disabilities Act's prohibition on disability-based discrimination. The next bullet item, what is protected by state law? State law provides a broader list of protected characteristics under both the Iowa Civil Rights Act and Iowa Code Section 280.28, which is Iowa's law against bullying, harassment in schools. I'm going to pick a few additional characteristics that go beyond federal law, such as physical attribute, ancestry, political party preference, political belief, socioeconomic status, or familial status. So the next couple of bullet points: what does race and sex scapegoating mean, and what does race or sex stereotyping mean? For the exact language, I direct your attention to the guidance document, but I'll give you a brief elevator speech on each. Race or sex scapegoating means that an individual, based on her or his membership in a race or a sex is inherently and consciously or unconsciously inherently racist or inherently sexist or oppressive. Race or sex stereotyping, a short elevator speech on that is presuming that you can determine an individual's character, values, moral or code or ethical codes, privileges, status, or beliefs because of an individual's race or sex. That if I am a woman, I believe X. If I am an African American, I believe Y. That is prohibited race or sex stereotyping. House File 802 sets out specific defined concepts. There are 9 listed and then a 10th catch-all. Pardon me while I briefly summarize each of them. Item 1, that one race or sex is inherently superior to another race or sex. Item 2, that the United States of America and the state of Iowa are fundamentally or systemically racist or sexist. Item 3, that an individual solely because of the individual's race or sex is inherently racist, sexist, or oppressive, whether consciously or unconsciously. Item 4, an individual should be discriminated against or receive adverse treatment solely based on the individual's race or sex. Item 5, that members of one sex or race cannot and should not attempt to treat others without respect to race or sex. Item 6, an individual's moral character is necessarily determined by the individual's race or sex. Item 7, an individual, by virtue of the individual's race or sex, bears responsibility for actions committed in the past by other members of the same race or the same sex. Item 8, that an individual should feel discomfort, guilt, anguish, or any other form of psychological distress on account of the individual's race or sex. Item 9, meritocracy or traits such as a hard work ethic are racist or sexist or created by a particular race to oppress another race. And item 10 is a catch-all, any other form of race or sex scapegoating or any other form of race or sex stereotyping. So what does House File 802 not do? As noted before, it does not sort of end a district's option and responsibility to continue to have efforts to promote diversity, equity, and inclusion for students and staff. By the House File 802's plain language, a school district is still permitted to do so. By its plain language, House File 802 is to be construed consistent with the First Amendment. So read House File 802 in conjunction with House File 744's protection of intellectual freedom. And last, House File 802 does not eliminate the ability to discuss racism, sexism, racial oppression, or segregation as a part of a broader course of academic instruction. House File 802 specifically provides that it should not be construed to prohibit the use of curriculum that teaches the topics of sexism, slavery, racial oppression, racial segregation, or racial discrimination, including topics related to the enactment of racist, racially oppressive, sexist laws or laws that impose or require segregation or discrimination. There are other provisions of House File 802 that are primarily of interest to lawyers, which, being aware of the intended audience of this webinar, I'm going to skip over. The department will monitor compliance with House File 802 in the ordinary course of monitoring. Since Section 2 of House File 802 requires each district's superintendent to provide an assurance that that the district will comply with House File 802. We expect that be added to the list of annual assurances, and districts will be selected for additional monitoring based on the department's differentiated accountability framework. If you have any questions about differentiated accountability, please reach out to your school improvement consultant. And the department is still determining whether rules are necessary to fully implement House File 802. House File 802 does not require the department to issue rules, and we're still reasoning through whether or not a rulemaking would add anything to the plain language of House File 802. Next bill, a large bill, House File 847, Education Practices, but the relevant provision requires the Pledge of Allegiance. So 3 things. Each school district is required to daily administer the pledge to students in grades 1 through 12. Requires each school district to display the United States flag when the pledge is being recited, and prohibits the district from compelling a student to recite the pledge if the student or parent objects to doing so. So if either the student or the parent objects, the student shall not be required to say the pledge or salute the flag. This is consistent with a 1943 US Supreme Court decision, West Virginia State Board of Education versus Barnett. So both under House File 847 and the Barnett case, a student or their parent has the ability to opt out of reciting the pledge. Last couple of items are from policy items that were part of House File 868, Education Appropriations. Couple of things. The first bullet point requires the director of the department to distribute to districts 3 things: general guidance for parents, guardians, and community members who have concerns about the district or its board of directors. Item 2, standards of practice for equity coordinators. And 3, a training program on free speech under the First Amendments, which districts must use to provide training to their equity coordinators. The second bullet point on this slide, voters in the district are allowed through a petition process to place an item on the next school board meeting agenda, including curriculum concerns. If a school district's electors, if the certain numerical threshold, sign the petition at the next regular or special meeting of the school board, the school board and the administration is required to hear and receive public concerns. While that process is pending, school leadership, if the concern is regarding curriculum, the school leadership may, but is not required to suspend use of that curriculum pending the outcome of the discussion before the school board. This petition process is not a means to raise concerns about personnel decisions or teacher assignments. Iowa Code Chapter 279 creates sort of the exclusive mechanism by which teachers are hired and promoted and terminated. So this is not the vehicle by which those concerns are surfaced. Personnel discussions, there's another lane and another procedure by which those are addressed. And the last couple of items, districts must include in student handbooks reference to or include the content of the department's parent, guardian, and community concerns page, and requires the district's board of directors in providing annual training to equity coordinators to use the department's developed program on free speech protections. So thank you for paying attention to this quick sprint through this content. If you have any questions, please reach out to your district's school improvement consultant. If she or he is unable to assist you, your school improvement consultant will route your concern through the department until they find somebody who can address your question. If you have any additional questions regarding these broad topics of equity, feel free to visit the department's equity education webpage, the department's main webpage, educateiowa.gov. And with that, I thank you for your attention to this recording. I hope that you have a safe and healthy and productive coming school year. Thanks for your attention.